Hello, everybody, and welcome to today's webinar on cookies and the Data Use and Access Act, the DUAA. Staying safe and lawful, and we're going to cover some of the key areas to consider. And today's webinar is being led by Rowenna Fielding and Ralph O'Brien. A few things to run through before the webinar starts. My name's Crystal. I'm one of a team of consultants that work for the Data Privacy Advisory Service. We're the company today hosting the webinar. We're based in the southwest of England, and we offer a comprehensive package of services and all things data protection related, from training, audits, including support for DSPTs, support with subject access requests, policy design, and we also provide an outsourced DPO service. The webinar is going to be recorded, so if you do miss anything, you will have the opportunity to catch up with it later. Just some things around housekeeping. The webinar is going to last approximately 1 hour. Please ask questions in the chat. After the webinar, we would appreciate it if you could complete the survey that will be emailed to you following it. We do like to receive feedback, the good and the bad. We like to use the information not only to improve our service, but also understand what subjects and areas you would like covered in these webinars. So now I would like to introduce our two most excellent speakers today, Rowenna and Ralph, to take over from this point. Over to you guys.
Okay, well, thank you very much. Yes, we lost the PowerPoint for a second. That's always a good start, isn't it? Thank you very much for joining us. As we've been said, my name is Ralph O'Brien. I run the newly created Serious Privacy and Data Protection business, and of course joined by the affable and knowledgeable Miss IG Geek, Rowenna Fielding, who is going to give us a wonderful little talk today about what's going to happen around cookies and the Data Use and Access Act, though the webinar is slightly mistitled, I think, because something to note about when we're talking about PECA is it's not just about cookies. I think, Rowenna, that's the perfect jumping off place. Why are we not just talking about cookies today?
So, myself, Rowenna Fielding, aka Miss IG Geek, professional data protection nerd, certified data ethics professional, ePrivacy enthusiast, human rights advocate, want to tell you all about the DUA, the effect that the newly minted Data Use and Access Act has on online tracking. So, as Ralph said, this is not only about cookies. We've titled the webinar about cookies because that's what everybody recognizes. That's what the search engine optimization is best for. But it's really, really important to note that this is not only about cookies. So also other technologies like web pixels tracking beacons, local storage objects, e-tags, some kinds of device and browser fingerprinting, unique identifiers. And I'll go into that more and explain why more in a moment. If you don't know what those things are, then it's definitely worth doing a bit of research. I've got some really good articles which I'll happily send on to DPAS for onward distribution. Some of them were even written by me. So yes, this is not just about cookies. This is about ePrivacy. ePrivacy is all about the confidentiality of communications over a public telecommunications infrastructure. That's the internet, basically. So,
well, let's jump in here because actually we talk about a public telecoms infrastructure. The internet is set up over phone lines, and therefore, it's also worth talking about the fact that PECA also applies to things like telephone calls as well. We're talking about confidentiality of communications. People who know me know that I'm a big fan of talking about data protection, not privacy. However, we actually are in the realm of privacy here. We are in the realm of talking about the fact that this is about the big offence under PECA is unsolicited communications. And of course, when it comes to cookies itself and other online forms of tracking, we have to understand the fact that PECA really looks at permission to access a device. And I think that's the sort of the perfect place to start, isn't it?
Yeah, so I'm not going to read all the way through this, not least because it's now obsolete. This was the original text of the Privacy and Electronic Communications Regulations 2003, which basically says, if we could have the TLDR slide, please.
Yeah, I mean, for me, it's about just being polite, isn't it? It's about saying if I want to put something on your device, I need to ask your permission.
Yeah, it basically says keep your hands, nose, eyes, etc., out of other people's devices and away from the info on other people's devices, or rather, the official language is the terminal equipment, which is the end user's bit of kit. So stay off it unless it's totally necessary for that specific communication to happen, or they invited you in and said, yes, put stuff on my device, or yes, read stuff off my device, or they've asked for you to do something that requires you to do those things, and you've explained clearly what you're doing, and on receipt of that explanation, they didn't go, yeah, no.
It's the
So,
analog to the physical world I like here because like you wouldn't just turn up at someone's house and then just drop a listening device in their front door and say, okay, see you, bye, without getting permission, right?
no, these days we install them ourselves. Ring doorbells, Alexa. Yeah, that's another rant for another day. So that's what the original said. The Data Use and Access Act modifies PECA and says, don't do those things unless you can tick one of the boxes in Schedule 1A, which is also new. But the rules are still don't look or touch unless you can do one of the things that Schedule 1A allows you to. Also, the Secretary of State can make up their own new rules, as is the common through pretty much all of the DUAA. The Secretary of State gets to just change it. However, this particular provision can't be changed by the Secretary of State unless they have consulted with the Information Commission and got parliamentary approval. And I think this is the only provision where they actually have to seek consultation and authorization from elsewhere. Everywhere else in the DUAA, the Secretary of State can just go, nah, everybody has to wear silly hats, and then that's the law.
For those people who don't know who the IC are, the IC, you will be familiar with the former ICO, the Information Commissioner's Office. But in March, the Data Use and Access Act commencement regulations came in, which means technically and officially, though they haven't rebranded their website yet, the ICO, the Information Commissioner's Office, is now officially the IC.
Yep, they just took away the office. Okay, so what this is the text of Regulation 6 PECA amended by the Data Use and Access Act. And I'm not, again not going to read all the way through this because it pretty much says the same thing. But for those of you who will want to look up this bit of the legislation in future, it's here in the presentation. So again, keep your eyes, hands, nose out of other people's devices and information unless. And it's Schedule 1A. If we could have the 1A slide, please, my lovely assistant.
This is what I'm here for now. I've purely been reduced to the role of glamorous assistant.
Well, you are so glamorous. So yeah, Schedule 1A, and it's like 3 pages long, so I didn't reproduce it here on the slide. I've summarized it. Important to note that even though it says website in the legislation, that doesn't just mean a set of pages rendered by HTML in a browser. It means web presence, any kind of web presence, any app, even if it only works over Wi-Fi, it's still a mobile app. Even if it goes on an iPad, it's still a mobile app. Or any other information society service platform. Now, that might be a phrase that you haven't encountered before, so I'm going to hand over to Ralph to explain what information society service means, because he knows more about it than I do.
So you may actually have entitled the term information society service when looking at children's consent under the UK GDPR, or in fact the EU GDPR. It's a phrase that is kind of was originally quite nebulous, but there was a court case that really defined it. So an information society service is essentially something you do online where you have to register for some sort of account or get some sort of service. Now, there are four legal tests to be an information society service. So it has to be provided at a distance, so not face to face. The user and provider are not in the same physical reality. It has to be provided by electronic means. So again, much like PECA, internet, apps, email, digital networks, telephone, anything like that. Not a purely physical service. It's got to be provided at the individual's request or the recipient's request. And that's interesting because that means the individual's got to choose to access the information society service. It can't just be a passive broadcast like television, for example, or radio. And normally, and this is the slightly nebulous one, it's normally provided for some sort of remuneration, some sort of payment or electronic activity, economic activity. So that does include things that are funded by ads, because you are registering for account, and even though the service is free, you are actually the product and therefore being sold to advertisers. So anything collecting user data as part of a business model would count. So provided at distance, electronic means, at the request of an individual, provided for enumeration or other sort of benefit. So the sorts of things that would count: social media platforms, Facebook, LinkedIn, online shopping sites like Amazon, streaming services like Netflix, search engines like Google, mobile apps, software as a service platforms, but not things like traditional TV, radio, offline services, or even physical services that you might have booked online but is delivered offline. A lot of people just say, oh, it's just having an account online. But if that account is to access a physical service, then it's not considered an information society service. Is an interesting wrinkle.
Though there will be some hybrid models, which is the outliers and edge cases, which will make for interesting case law in the future. So Schedule 1A of PECA, amended by the DUAA, sets conditions under which you are allowed to put information on or read information off the end user's device. And that is if you've got their consent. And consent, of course, follows the GDPR model. It has to be informed, freely given, specific, unambiguous, revocable, and evidenced. That's like the 6 tests of consent. And it does allow for browser settings to automatically indicate consent, or for another application to have already given consent. Interestingly, it's gone with browser settings can give consent, rather browser settings can object, which I think everybody would have preferred. But that's, I suppose, what happens when you let the advertising industry lobby for legislation.
So in the UK, via everyone's browser, you still have do not track as a setting, and coming out to America, we've now got what's called the Global Privacy Control (GPC),
And a bit
and
more
actually,
about those in a moment.
yeah, in California, they're actually on a legislative basis. So it'll be quite interesting to see how that evolves when you've got browser settings saying no as well.
So consent is the first option, where the read-write operation is technically necessary for the transmission of the communication itself. So I don't know about you, but I've certainly heard marketing teams make the argument that their ad tech cookies are necessary because the business couldn't survive otherwise. That doesn't count. It's got to be necessary for that particular communication between the end user and the site, app, etc., platform operator to happen at all. So technically necessary is it's quite a high bar to clear. Things like load balancing of streaming platforms, for example, would count. Then you've got the Information Society Service provision, and only where the read or write operation is strictly necessary. So that's for things like authentication, and security of the platform, security of the device, fraud prevention, troubleshooting, and performance where it's focused on the site itself, not on the user. And then the last one, which is the one that has been generating quite a lot of kerfuffle, is for statistical analysis, where it's an information society service, and the read-write operation and subsequent data is used strictly for the purpose of analyzing how the website is used or is performing. So it's got to focus on the site and the service, not the individuals using it. And that's really, really important because there is a lot of misinformation out there at the moment. People saying things like, "Oh, it's fine to do anonymous analytics now, as long as it is anonymous and you declare the cookie." No, as long as the analytics are focused on the site, the usage of the site, the performance of the site, not the people using it.
This is the real concern, isn't it? That people will just now see, oh, statistical analysis is okay, and
Already
then
happening.
load yourself up with Google Analytics cookies and all of these other cookies that will just monitor the individuals to the nth degree.
Yeah. So that's really specific in the legislation. I think a lot of the articles that are being published perhaps are not written by people who've actually read this legislation. They've just kind of got it third hand, or worse, asked some LLM or something ridiculous like that. So now you know that PECA and the DUAA, the TLDR, says keep your hands, nose, eyes, ears, etc. out of people's devices unless it's totally necessary for the communication to happen, or they invited you in, or you need access for one of those necessary purposes mentioned on the previous slide, and you have clearly explained that purpose, not just said something like, "We use this for marketing purposes," or which doesn't even count anyway, or "We use this for security purposes." Well, does that mean looking at IP geolocation to identify spammers, or does it mean authentication of a secure session, or does it mean making sure, XYZ ban users don't get onto the platform? You've got to explain. And the last condition is, or the end user, has asked for something that requires that access, and you've explained clearly what you're going to do, and they didn't say no. So
But this
that
is
would
the
be.
problem, isn't it? This is the problem. Like, you've got to clearly explain. And so people already have cookie consent banner fatigue or other tracking fatigue. So now we're asking them to give more information to the individuals. Does that mean the individuals will read that information, take it in, and make informed choices? Or does that mean the individuals will see these banners with lots more information and just click accept? What's your thoughts?
I think this is where the layered approach is probably the best, the compromise. So while in the first layer you can say something like this piece of tracking code, or this cookie, or this beacon, etc., allows our online chat to function. And then have a link or pop up or something else where the interested user can go and look further and see, well, what does that mean? Exactly what's happening? What is the effect on me? What are how long is this going to stay on my device? How do I get rid of it? All that jazz. So giving people a clear signpost to as much information as they want to access is the sort of middle ground between bombarding people with information they really don't care about, they just want to be left alone, or just running roughshod over their devices without them having a say in it or even visibility of it. So layers are good. The user experience of a lot of these layered mechanisms in consent dialogues is is not great. Um, and if I had a suspicious and jaded mind, I would suspect that they're not great, so that people just give up and accept the thing without looking into it too much further. But then maybe I'm just a miserable old bat. Who
So
knows?
another opportunity for deception by design. Got
Yes,
it.
yes.
Right. So what's changed? What is the big difference then between what was before and what was after?
Not an awful lot, really. We now have a helpful list and criteria of what is allowed through when it is the word in law is strictly necessary, but as we know, the various consent management vendors use all sorts of different wording: essential, critical, necessary, functional, rah rah rah. We now have a list, a very clear list, and so it's harder to wriggle around the the kind of strictly necessary criteria by calling it something else and pretending that there isn't actually a list in the legislation, because there is now. Objection must be possible sometimes. So going back to the if it's something for an information society service, for example, like measuring the performance, the load time of the site. Note, not A/B testing. A/B testing is never strictly necessary, ever. A/B testing is a nice to have for the operator of the site. It's not something you cannot go running double-blind experiments on random end users without their knowledge and consent. I mean, it's rife, but it's technically not allowed. So objection must be possible sometimes, and again, the criteria for when objection is possible is laid out. There is no specific mechanism defined for objection, and we're going to talk a little bit about the TLAs, DNT, and GPC in a moment. And again, in contrast to PECA, the Secretary of State gets to change the rules, but in contrast to the rest of the DUAA, they can't just do so unilaterally. They have to have agreement in order to do so.
To me,
So,
the biggest change actually is, in a way, that PECA enforcement has been brought into line with GDPR. So the fines and the penalties are going to be allegedly the similar thresholds that we know and love from the GDPR. In fact, that was the last provision of the Data Protection Act 1998 has now gone. Because actually PECA fines, believe it or not, done under Data Protection Act 1998. But they've now been brought in line with the GDPR, which means theoretically much bigger fines. But then you contrast that with the mission of the ICO has changed, which is promote the economy, promote innovation, make sure that the UK is a sexy place to come and do business. This is now the mission of the ICO under the Data Use and Access Act. Does that mean we've sort of got a contrasting imperative here with the ICO?
well, I mean, you could look at the enforcement statistics over the past 10 years and draw conclusions from that. So, yes, in theory, um, violations of PECA can now be dealt with as harshly as violations of the GDPR. Brackets, your mileage may vary according to your local regulator. Right, so going to go and do a bit of myth busting, and these are myths that I have encountered on various platforms, at conferences, on LinkedIn, on Blue Sky, places where people meet up to exchange information, often information society services. And I want to bust these myths because they're really unhelpful. And the one I mentioned earlier is that analytics cookies can now be used without needing consent. No, that's not a complete myth. It's not total nonsense. It's partly true. First of all, it doesn't just apply to cookies. It applies to other forms of digital tracking technology which get information from or push information to an end device. So partly true, it's not just about cookies. So tracking technology involving push or pull of info to or from client device can be used to gather statistical analytics without consent, but only for analysis of the site or app or platform performance, function, or use itself, not the people using it. And the output cannot be shared with any third party for different purposes. So you could get perhaps an organization in to give you shiny dashboards and reporting on the raw analytics data, but they can't then go off and take that data and use it for anything else. So essentially, they'd have to be a processor. And the purpose of the tracking is clearly explained to the end user. So no deception, no ambiguous language, no obfuscation, no spin, kind of. And the end user has the means to object, which is easy and free and doesn't require them going down to the basement, opening the filing cabinet and dodging the beware of the leopard sign, but they haven't actually objected. So those are the criteria under which analytics tracking technology, cookies and other things can be used without consent. And as you can see, that is a really narrow band. It does not include Google Analytics. The reason it does not include Google Analytics, sorry, the reasons is that it fails the first test because Google Analytics is, even if the site operator is using it to profile use of the site, Google is using the data to profile individuals, and there's nothing you can do about that. The output of Google Analytics for the site operator gets to see a very limited data set. Google sees everything and it's shared throughout the entire Google massive corporate extended family, which is like 300 odd companies. And the purpose of the tracking, well, I don't know if you've seen the default explanations of Google Analytics, but they don't bear a lot of resemblance to what's actually going on under the hood. And the user has the means to object. Well, you can clear the cookie, but you can't claw back the data that's already been sent. And if the site is not honoring do not track or global privacy control, then there isn't really effectively a means to object either.
No, this is one of these issues where I see all the way through the Data Use and Access Act. Let's make things easier, they said. And by making things easier, they've added this layer of specificity that people, generally speaking, aren't going to read, look at, or probably even adhere to. And I can't see it being enforced anyway. Correct me if I'm being the cynical one for a change.
Not enforced, it may be litigated, and that's something that a lot
Which is
of
expensive, beyond the reach of most people.
it's true, it is expensive beyond the reach of most people, which is why class actions exist, although they've not had the most successful history in the UK.
Google
Um,
Lloyd.
Sorry?
Google Lloyd, indeed.
Indeed, yeah. I mean, that took entirely the wrong approach in my opinion, but what do I know? I'm not a lawyer. Um, so yeah, so let's stop ranting about Google and let's go on to the next myth, and that is that cookieless tracking is better for privacy, or that cookieless tracking is exempt from cookie laws. This is entirely false. Server-side tracking, so things like custom URLs where you can identify the incoming connection as a specific user because they've been assigned a specific code-generated URL, or e-tags, which are bits of code that identify a device, or fingerprinting. Oh, we've got a Google question in the chat, which we will get to at the Q&A. Fingerprinting, all that is stealth technology. It is essentially covert spyware. And so that's not better for privacy. It might be better for not interfering with the end user's frictionless experience of your site, but it is not better for privacy. Better the devil you know. So that knocks the first one on the head, and that's usually said by people who think that the ePrivacy law is just all about cookies and all about dialog boxes, and don't really get that it's about confidentiality of communications.
Yeah, and actually, let me just, and actually, this comes down to the question we've seen in the chat window as well. There is a difference between PECA and GDPR. There is a difference between what the GDPR says here about transparency and legal basis and permissions under PECA. Now, I agree they're normally done in the same consent ask or the same transparency notification, but the rules under who's a controller, who's a processor, what's the legal basis is almost entirely irrelevant for PECA because PECA operates under its own rule set, generally speaking, albeit they use common terms like consent. And therefore, you might well say under GDPR, I need to be transparent. And under GDPR, I'm the controller and you're the processor. No, PECA just says if someone comes onto your site, almost doesn't matter who's doing it, as an information society service and you want to put something on their device, you either have the permission or you can use one of the exemptions. Forget about, GDPR, right?
Interestingly, PECA does not take any notice of the GDPR, but the GDPR does take notice of PECA.
Yeah.
So that only goes one way. You can't say, oh, let's just only talk about PECA and forget about the GDPR, because if you breached PECA, then any subsequent processing of personal data will be unfair, unlawful, excessive, all that jazz.
Yeah.
So PECA comes first, but if you're looking at the GDPR, you need to look to see if PECA should have come first. And so the other reason that cookieless stuff or server-side tracking is not better is that the rules apply to those other types of tracking as well. They apply to any kind of read-write access to information on the end device. Slightly challengingly, a lot of web development outfits these days don't so much do web development as they do graphic design using building blocks for the web. So whether or not they have underlying understanding of the code architecture, the system components, the data flows is something that you cannot take for granted. The number of web developers I've encountered lately who could not identify where a cookie being set was coming from, which part of the site they built was setting the cookie, because all they did was assemble pre-built modules and they didn't actually understand a lot at all about web coding.
That's extremely true. Yeah. With things like AI as well, building code for people with third-party providers who will build your website for you. Often the person who is creating the website actually has very little control or indeed understanding of what's going on the site they've created.
Yeah. And there's a lot of web developers who are not really web developers, they're graphics designers with delusions of coding.
I like that.
Okay, so myth busting number 3, which is something that you will see the government and the IC and a lot of sort of establishment figures saying is that, oh yes, the DUAA makes all these things so much simpler and easier in order to boost the economy and promote innovation and yada, yada, yada. Well, I don't know about you, but I don't think that having a third piece of legislation to have to check against, so on top of the Data Protection Act 2018 and the all the stuff that came from the original UK GDPR Withdrawal Act, the various Keeling schedules, I don't think that having another set of track changes to look at makes things easier. It does potentially make it more possible to clarify whether what you're doing is in line or not in line with the legislation. So the added specific list in Schedule 1A is jolly helpful. But it's not easier because the rules haven't evaporated. They've just changed. And you need to stay on top of the changes. checking the new consent exemption criteria adds more work. So if you want to know whether or not you can dodge around the effort of consent for certain bits and pieces, you have to do the work to then go and analyze what's happening on your site and how that's working and whether that fits into the criteria in Schedule 1A. And if so, you know, how are you going to still provide that information to people? There's no reduction of workload there. It's actually increased.
And that's been my experience with my clients. My experience with my clients has been they've come to me and gone, brilliant, we've now got all this new stuff. The DUAA is going to make everything better for us, so we can just do all this stuff. And I've said, yeah, the exemptions are really limited. And so you've got to do your homework and check whether you can do them. And they've mostly gone around and gone, well, that sounds like too much effort. We're not going to use them.
Yeah. Yeah, it's similar to the charity soft opt-in. Pretty much all the charities I've spoken to, once I've laid out the amount of work they have to do in order to do it safely and lawfully, they've gone, nah, can't be bothered. So the other thing that the DUAA doesn't do is that it doesn't make the GDPR evaporate. Even if you have followed all of the PECA rules, you still also have to consider applying the GDPR. So if you're if you have acquired personal data through some kind of PECA mediated access, so you've read it off someone's device or you've put it on someone's device and then gone back and collected it later, whatever. Even though you've complied with PECA, you still have to consider whether or not your onward use is lawful, fair, transparent, adequate, relevant, not excessive. God, the quality is good. It's only stored for a limited amount of time. It's secure, yada yada, all that jazz.
Where it's personal data. I mean, a lot of people don't even realize that PECA just applies if you're using a public telecoms network and you're setting cookies and tracking technologies that don't even use personal data. Then only PECA would apply.
Yeah, and there is and on the next slide, which segues nicely into the next slide, things to keep an eye on. Third-party stroke dual-use tracking technologies. So this is, for example, widgets, third-party widgets, social media widgets, LinkedIn widgets, Meta pixels, Google Analytics cookies, basically anything that can be initially presented as being relevant to performance or necessity, but also provides the functionality which is taken advantage of doing profile on an individual basis as well. The reason and so if it's free, generally, it's probably not going to be safe to classify as single use. Because the reason big tech provides these tools, free code, widgets, modules, software development kits, libraries, etc., is so that they can get the data to your website flowing through their servers because it's extremely valuable. So read the T's and C's and the privacy notices with an extremely critical eye. And not just that, go to that third party's marketing materials and see what they claim to be able to do. So if they say, you know, we can narrow down your customer demographic to, you know, postcode areas, gender, ethnicity, and income bracket, then you know that their claims that our bits of kit don't profile you or are anonymous are nonsense. They're not true. So look at their capabilities. They will tell you far more about what's happening than the information that they're legally obliged to publish, but which no one is actually checking to see if it's truthful. Not that I'm jaded and cynical or anything. So keep an eye on the third-party stuff and also your web developer. Make sure they are or have access to an actual web developer who actually understands how to unpick code and functionality. Anonymous tracking. This is where we hit the language difference. Interesting thing. In the US, anonymous is used to mean de-identified and pseudonymous data. So because they're all about PII, personally identifiable data, if it doesn't have PII in it, they consider it anonymous. But in European terms, personal data is any data that could identify an individual, including a mosaic of different characteristics, which each on their own is not identifiable, but you put them together and it forms a picture. So, for example, those nice two geeks who did the DPAS webinar on PECA and the DUAA, in US terms, that's anonymous because it contains no PII. In EU terms, in GDPR terms, it's personal data because, like, you blatantly know who that is. It points directly. We're not the only nice two geeks in the world. We're probably not the only two people doing webinars about the DUAA and tracking tech. But yeah, so when you're
What do
looking
you mean,
at
nice? Um, um,
meaning affable,
yeah, and
you called me earlier.
we're increasingly seeing those US words, PII, privacy, those sort of, US terminology, publicly available data, these sort of terminology that we're seeing, because, people are used to looking for American big tech, and American big tech is increasingly running our lives. And a lot of them genuinely believe they're beyond the scope of our local law, right? And if you're a large American company, why would you look at a small domain like the UK and go, "Oh, we've got to comply with the law," when the penalties aren't there? So to me, this is one of the problems we're actually finding, right? It's this kind of the default given to us by these large tech providers is now starting to becoming incompatible with domestic law.
Yeah. So never take claims of anonymous at face value. Dig into the functionality because you keep using that word. I do not think it means what you think it means. Um, Another thing to watch out for is unknown stroke undocumented cookies, which is usually the product of lazy development with uncommented code. Happens a lot where web developers just go and choose from, like, for example, the WordPress, I can't remember what they're called, modules, uh, apps, the WordPress bits and pieces you can slip on a
Plugins.
store. Plugins, that's the one. Yeah. They don't know who wrote it. They haven't looked at the code. They haven't put it through any kind of quality testing. They just see it and bung it in. Sometimes they see that it's free and bung it in. And that might end up doing things that were not anticipated. And then it's a real scramble to find out which bit of the site or app, etc., is setting this undocumented tracker and what it's actually doing and how do you get rid of it. So keep an eye out for those. Sometimes it's the result of sheer laziness, sometimes it's nefarious intent. There's no way to know. Be very wary of default cookie descriptions. Things like this this is used to assist users. This is used to provide insights. That tells you nothing about what it does, how it works, the privacy implications, the data protection risk. Especially things like the LinkedIn, default LinkedIn advertising, retargeting cookies, the Google Analytics, again, the double click, the Adobe, Oracle, Axiom, all the data broker stuff. None of them accurately and honestly describe what their cookies do. They are all spun so hard, they're practically a blur. If you want to know, again, if you want to know what it does, go and look at what these companies claim to be able to provide in terms of tracking and targeting. That will tell you what their technology does.
Look at the outcomes, definitely.
A lot of the consent management tools also, they just pull in default descriptions. They don't actually do their own work to figure out what a cookie does. So you really can't rely on what their classification of whether it's privacy safe either, because they're not checking. They're just repackaging and reselling a piece of automation. Because I'm a nerd, I have started building my own database of what these things really do. Yeah, it's kind of shocking.
Well, the golden rule is now with these exemptions, you can claim them as long as it's not really about the people, right?
As long as it's not about the people. Um, which is the last point, which is even privacy safe analytics may still not meet the Regulation 6 Schedule 1A consent exemption criteria. The basic test is this looking at the site functionality or is this looking at the people using the site? And if it's the second one, then you still have to get consent. Okay. So
So the last thing we're going to then talk about really is what to do. Yeah, what actions can we take to get on the right side, and how can I'm a big fan of saying, if technology is the problem, perhaps technology can be the solution, but that doesn't exempt us from critical thinking, right?
technology is not the problem, people are the problem.
Yeah.
So, yeah, what to do to stay safe, stay lawful, stay on the right side of law and PR, and not give your DPO, stroke privacy council, etc., a nervous breakdown. Uh, Due diligence and strong contracts on any third party who you are engaging to do web design, web development, digital marketing. You need to know that they understand PECA. You need to know that they understand what they're tinkering with. And you need to know that you can demand full documentation for the site, and they can't refuse. So write that into your contracts, do your due diligence, ask them what kind of education qualifications in terms of ePrivacy they're looking for. Until the demand for this is customer driven, there is no incentive for the web development industry to pay any attention to it. Right now, they're paying no attention to it, and you, the customer of web development services, is the one left in the lurch. So start holding them to account. Regular e-privacy scans, which there are plenty of tools out there of varying degrees of expense and functionality, but not just the scans. Take follow-up actions based on what the scans tell you. That's the important bit that often gets missed. Robust change management and governance, the usual stuff. Honor. Now, do not track is an old web standard. Well, it's no longer a standard because nobody bothered with it, because the advertising industry basically killed it. But it still exists. It still works. If your
Wow.
browser is sending do not track signals, and you go onto a site and the site honors the do not track signals, it will cease all tracking of your device. I have do not track turned on permanently because I use Brave browser. And when I encounter a site that honors do not track, I am filled with joy and more inclined to do business with that organization. It's not a legal obligation, but there is nothing stopping you, and it makes you look good and it avoids the hassle. GPC is not quite the same. It is again a web technology, web standard, global privacy control, but that is about the onward use of information. So that is more in the GDPR PECA crossover, whereas DNT is pretty much wholly PECA focused.
The nice thing about GPC is it's the first one that's actually got legislative support out of California. So even though it doesn't quite do the sexy stuff that DNT does, such as do not track me, GPC says don't send it to anyone else. But at least for the first time, we've got something enforced in law on the Californian tech companies.
Yeah, I have mixed feelings about that because and GPC, as long as you're not selling the data to anyone else, it's fine. But what you can do if you are certain organizations is build an incredibly detailed profile of that individual and then sell access to their attention and opportunities to influence them to other people, and that gets you around GPC. So I'm not madly convinced that it's a great thing. I think DNT should be resurrected. When in doubt, stick with consent. Do what you've been doing so far. Don't change anything. Or better yet, reduce the amount of tracking that is happening on your site.
Wouldn't that be nice? I mean,
Wouldn't that be
anytime
nice?
anyone posts anything on LinkedIn, I mean, my first answer is, forget, you don't have to worry about cookie banners and cookie consent if you're not tracking anyone. Done.
Yeah. And it has been proven over and over again that targeted advertising is less effective and more expensive than contextual advertising. But um, yeah, let's not go down that ranting. So, last thing just before we get to questions, privacy safe analytics. Remember, this is privacy safe. It is not necessarily Regulation 6 Schedule 1A test clearing. So this can still be about people. So while these analytics are privacy safe, they will not necessarily get you around the consent exemption. Plausible is the best one, I think, by far, although I don't have direct experience using it as a site operator myself. Matomo will depend on your configuration. If you configure it to work exactly like Google Analytics but bypassing Google, then there will be less privacy benefit because you're still doing tracking and targeting. However, you can configure Matomo to host it on your own server, in which case it's completely free, and to do a very bare minimum of tracking that is just focused on use of the site. So you can make Matomo clear the Schedule 1A test. Simple Analytics and Fathom are privacy safe. They're not PECA consent free, but they are hosted in the EU. And Cloudflare is US hosted, but it does seem fairly reasonable having looked through the T's and C's and privacy notice, and they've had it independently audited to make sure it's not sneakily doing other things in the background.
One of the big elephants in the room here is those large US tech firms that market themselves to data protection and privacy professionals as, consent banner operatives.
No context.
Yeah, and I shouldn't, we shouldn't name names, but people like TrustArc and OneTrust are probably the biggest ones in the game. They can be configured correctly, but there is an awful lot of interoperability between those tools and the marketing industry, and just enabling the IAF, the Internet Advertising, sorry, the IAB, sorry, the Internet Advertising Bureau, default settings, probably not going to get you through here.
Okay, so we've got 6 minutes, and I just want to whiz through some of the questions. So the question about the Google states it may process some data as a controller for security, fraud prevention, detecting abuse, service reliability, yada, yada, yada. Yes, it does. And that data, the security, fraud, abuse, debugging, etc., is not used for analytics. However, if somebody has either a Google account or a Google shadow profile, and they encounter a Google Analytics installation, then Google is a controller for all of the processing of personal data that is done by gathering information on either that user account or that shadow profile. So there is a clever loophole there, which is while what's gathered for security, abuse, reliability, debugging, product improvement, etc., is not processed for ad technologies. Everything the user does that Google can see is processed. So
And
that's kind
actually,
of hidden bit.
controller and processor is kind of almost irrelevant here, because here we're talking about PECA, and it is enough that you are operating the public telecommunications service. So it's really irrelevant who the controller and processor is from a GDPR standpoint, until you move down to the personal data route. But from the pure PECA operation of a public telecom service, and you're doing tracking and surveillance, who does it is almost irrelevant under PECA.
Yeah. So you have to look between the lines with the big tech and see what they're not saying. And having studied various bits of their information and the way they work, what they're not saying is that everything they do as a controller for Google accounts and shadow profiles is where all the ad tech stuff goes. So as soon as you put Google code on your site, you are grassing up your users to Google. Local storage and session storage, most websites are not able to list retention periods. Well, I mean, that's not a PECA requirement. They don't have to. If those are generating personal data, then they have to. But they can, the GDPR allows you to describe the criteria for retention if you don't have a set period at the outset. So you can say, well, we're going to keep it for this amount of time and then review it against the purposes to see if we still need it and then carry on keeping it for that amount of time. You don't have to have a fixed retention point at the outset. Where are we? Recommendations on how to identify the correct category for cookies. I mean, it takes a lot of work to dig that sort of stuff up.
Research, yeah.
Yeah, research. Because I'm a geek, and I used to be in salaried employment, which allowed me to do that. I have built up some of that information, but it's, yeah, you've got to take the time and the effort and the technical expertise.
The problem is, because the originally Privacy Directive was a directive, every member state of the EU built up their own cookie classifications. You know, you go to some countries and it's like advertising, essential, analytics. Other countries have got a strictly necessary. Other countries have got 4 or 5 different buckets, even within the technical side of things. So,
functional does not mean necessary. Those
yeah,
are not the same
yeah,
thing. That's a bait
functional.
and switch.
Yeah, so we've got a real terminology problem here in the entire industry. The buckets they put them in are not consistent.
I mean, if I could find somebody to pay me to maintain and update and publish my what cookies are really doing database, then I would be more than happy. But so far, nobody wants to actually shell out money for me to do that. So
That's the message from Adore here. It says, "Where can we find your list?" And I would say it's probably available at reasonable rates, right?
yeah, absolutely.
I'll take the next one. A healthcare provider with end-to-end patient journey digital considered an information society service? Yes, probably.
It depends.
Yeah, it does depend, because it has to be requested by the individual, has to be done at distance, not really physical, but normally provided for some sort of remuneration, which in this case it wouldn't be. So if it's NHS, but if private, possibly yes. So it's a real, it
One that
depends.
would.
Yeah,
There's third parties that do like transcription and make your documentation
yes.
available online. They would count. Bupa wouldn't.
Yeah, Bupa wouldn't, as far as I'm concerned. You're right, because there's the physical healthcare element in there as well.
Okay, I think that's all we've got time for. Again, as Ralph has said, we're available at reasonable rates. DPAS, of course, offer a whole load of education and consultancy services for these things. So I'm going to hand over to Crystal to tell you more about that.
Well, I just want to thank you both for a really interesting webinar today. It's certainly, I think I need to increase my reading around the subject as well. So I think you've provided some food for thought there. Thank you to everyone for some really great engagement as well in the chat and for the questions. It really does make the webinar a lot more relevant and engaging. So we hope you found the information discussed useful and that some of it you'll be able to apply to your business area. And just thank you again for coming along today and enjoying the webinar. As I said, you will receive an email following this just asking for some feedback, and please keep an eye out in the future for other free webinars. You can always visit our website to view the previous webinars that we've held and some of the blogs. And obviously you can look at all the information that we have around any training that we deliver. So thank you very much, everybody.